Hello. Our next session now is on Article 10. Article 10 is a total hodgepodge of a large number of subjects that are unconnected with one another, but we ought to examine some of the more important sections of Article 10. We'll not touch on every one because many of them are not that significant. But to begin, we're going to pull out the significant sections of Article 10, analyze them, and then try to evaluate all these sections, suggesting for several of them that there may be some opportunities for improving the Constitution as we stumble over these subjects in Article 10. This should also give us some lessons about constitutional draftsmanship, because we'll find some of these are quite flawed when you begin to analyze them. First of all, talking about flawed provisions, Article 10, Section 1 tells us that we may not ratify amendments to the U.S. Constitution unless we have the majority of members of both houses elected after the federal constitutional amendment has been proposed. Well, this is unconstitutional. There's a case some years ago that was brought by a state legislator to contest this provision. It was brought at the time that the federal Equal Rights Amendment was being proposed. When the proposal passed the House and went to the Senate, some senator raised a point of order saying that they could not take it up because of what was in Article 10, Section 1. And so a legislator named Trombetta brought a case in federal district court and had this provision declared unconstitutional. And so it's in our Constitution, but it's unconstitutional. Militia, we need not linger on this, but if anybody asks you if you're a member of the state militia, the answer is probably yes. Probably everybody in this class is a member of the state militia. I think even geezers are, like me, are members of the state militia under this constitutional provision. Vacancy in office, you just need to read this provision. We need not linger over it. We will see some case law, and it becomes important on many more instances than you would think. And it tells us when a vacancy occurs, and that becomes important because very frequently someone either fails to qualify after election or is subject to any of the other provisions of this that mean that the office which they're supposed to hold is actually a vacant office and subject to appointment or otherwise. Homestead exemptions, we've talked about homestead exemptions and taxation. We now come to a different kind of homestead exemption, but one that again is of great interest to bar examiners who like to ask homestead exemption questions. In Article 10 homestead exemption questions, we're talking about exemptions from forced sale. I think we might refer to this as Florida's invitation to felons act or provision, because a number of people who are in danger of being sued and having damage actions successfully brought against them will come to Florida, establish a homestead, and even where a judgment is obtained against that person, if they're a Florida resident living in a Florida homestead, that homestead may not be subject to forced sale. So if you want to hide assets, buy a large mansion in Palm Beach or Fort Lauderdale and declare a homestead exemption, And when you do that, you now have very valuable property that is not subject to forced sale to satisfy a judgment. Florida is one of a handful of states that has such a provision, and it's one of the states that's in the Sun Belt and becomes very attractive if you're someone like O.J. Simpson. Subsection 1 just tells us what the extent of homestead is. There are restrictions on your alienating homestead even through a will, and those are covered in subsection C. Section 5 of Article 10 deals with property rights of married women. You do recall that at one time we had a disability of married women holding property, and that has been entirely removed in the Florida Constitution, originally I think in 1868, but it's clearly unconstitutional now in Florida. Eminent domain. Let's think through a provision of the Florida Constitution which says that the state may not take private property except for a public purpose and give full compensation. Now, as we look at the case law, full compensation includes the total value of the property plus attorney's fees. So if your property is taken away, you now can make claims against the state for recovery of the value and recovery of the cost of bringing the litigation. So full compensation. And note that eminent domain can apply both when the state brings an action for eminent domain and when the state acts in a way that takes away your property, and that you can bring a suit in inverse condemnation. So we now have property rights protected from the government. What happens if government takes away your liberty? What if the state convicts you and DNA testing shows that in fact you're innocent? What if the state convicts you by using perjured testimony, using phony evidence of some kind? What if the state fails to reveal to the defense the existence of evidence that would exonerate the accused? The state acting wrongfully in that way takes away your liberty. Are you entitled to compensation under the Constitution? The answer is no. The Florida Constitution protects property rights, but does not protect your rights to freedom. There are further provisions in this section relating to taking of easements for the drainage of land, and a provision that is intended to displace any possibility that in Florida, a federal court decision that was quite unpopular with the Florida legislature could be put in place. And this says that if you use eminent domain to take property, it may not be conveyed to a private entity except as provided by general law passed by 3/5 vote of the legislature. So a protection against the state taking your property and turning it over to another private entity, individual, or corporation for some other purpose. Lotteries in Article 10, Section 7. Lotteries are prohibited. Now, don't believe that, and we know that's not true because we've seen that lotteries, state-sponsored lotteries, are allowed, and we'll see something more about that in several of the upcoming sections. Census. This becomes important to us for several reasons. It was extremely important back before the 1972 revision of Article 5 because remember the number of circuit judges would increase if the population increased by every 50,000 people. And so the key to whether or not we had additional circuit judges were the figures in the federal census. And now, under the Florida Constitution as amended in 1968, we now have a provision that governs when the census figures will apply. But this provision is not just because of the old Article 5 language relating to the number of circuit judges. It also is here because of population acts. Remember when we looked back in Article 3, Section 11 at the population acts, we looked at the prohibited acts, including general laws of local application, and the general laws of local application included population acts, so that legislation might be adopted that would say that in counties with a population of more than 100,000 but less than 300,000, such laws shall apply. Well, that kind of category are general laws of local application. But now if you have a new census and the population figures change, suddenly you're going to find that additional counties are thrown into the above 100,000 population. And it may be that some counties are thrown out of the above 300,000 population. And so this provision of the Constitution gives some protection from the automatic application of population acts where that application had not been intended. A quick section 9 on repeal of criminal statutes. If you commit a crime at the time a criminal law is in existence, even if it's later repealed, you may be punished for violation of the law as it existed at the time that you committed the act. We have felony defined. It means any criminal offense that is punishable by imprisonment, by death or imprisonment in the state penitentiary. So if the imprisonment is in a county jail, it is not a felony. So note the importance of that. And in this whole area, I hope it's an area we have a chance to talk about in more detail. Florida in 2014 imprisons about 104,000 of its citizens. And if you calculate the cost of that at approximately $21,000 a year, so 21,000 multiplied by 100,000, you find that Florida spends an enormous amount of money locking up its own citizens. And it's a subject that really could be subject to a further discussion and maybe even a future Constitution revision to give some protection from this kind of criminal justice system. Sovereignty lands is important. Those of you who wind up practicing property law will want to be familiar with sovereignty lands, and that is that the land that's under navigable water is the property of the state, and private use of sovereignty land can be allowed so long as that use is not contrary to public interest. So many of you have seen docks, piers out over sovereignty lands, and those are there because they've been permitted. Rules of construction that apply throughout the Constitution, these can become important. Vote of the electors means the vote of the majority of those voting on a matter. The vote or other action of the legislature, when it says that it should be of the membership, it means all the members of that house. And the term judicial office, justices or judges, does not include municipal judges or other courts that are set up for the violation of municipal ordinances or county ordinances. And special law means a special or local law. And you do not use the titles or subtitles for construction. Constitution says that, but always the titles will give you some context, and you should pay attention to the titles. Now, suits against the state. Remember the phrase, the king can do no wrong? You would think that we got rid of that idea back in 1776, but the idea of sovereignty still exists. Originally, the idea was you can't sue the king in royal courts because the king doesn't give judgment against himself. And so this idea of sovereignty rising in Great Britain has stayed with us, sadly, since that time. So now in Florida, the legislature has made limited provision for the recovery of damages against the state when the state commits torts. But we have this anomalous situation that where the state commits some act which would be actionable if a private person did it, is now subject to these special rules under current legislature. In 2014, the legislature now allows damage actions to be brought and recovery made for damages under $100,000 per person or $200,000 per incident. But if any damages are returned by a jury for a greater amount, you have to go to the legislature and get legislation passed to now have a legislature, in essence, adopt laws that enforce that judgment. So you take the state out of the normal judicial process and put them in a special category. As you begin to think about all the misdeeds of state outside of the state's taking of your private property, you've got to realize that a great deal of evil gets done by the state and is not subject to any effective remedies despite the other provisions of the Florida Constitution. This is an area that begs out for reform. Provisions in Section 14 relating to retirement systems and the requirement that any increases must be accompanied by provisions for the funding of those increases. And the state retirement system has been for some years and remains quite sound. We've now moved to Section 14, state-operated lotteries. This is a provision of the Constitution that I drafted at the request of the then Commissioner of Education, Ralph Tullington. And look at how it's structured. Let me say, at the threshold, I did a terrible job of this draftsmanship. It's pretty simple. Has two subsections, and then a provision that's called a schedule. Lotteries may be operated by the state. And then a provision that says that if any portions of this amendment are held to be unconstitutional for containing more than one subject, this amendment shall be limited to subsection A above. So what is in this provision except A, above? And the answer to that is that there is a subsection C which says essentially on the effective date, the lottery should be known as the Florida Education Lotteries, and net proceeds derived from these lotteries shall be deposited in a state trust fund. So here's where the drafter made a terrible mistake. When this was drafted, the thought was that if you have a lottery provision and you designate the money for the use of education, state legislature, when it gets the money, is going to use the lottery money for education. And if you look at the claims of the state lottery, you might think that that's happened, and we'll talk about that in a minute. But what has happened instead is that the state legislature then accepted the funds from the state lottery and replaced and took those funds to fund education, took those funds out of the educational funding formula, and so general revenue was removed from education. Lotteries replaced the general revenue, and we have no improvement in education as a result of that. So look at the press, which tells us that 32% of the funds collected by the lottery went to education, and those included the general lottery fund and the money from the Broward County Casino provision, which we'll look at a little bit later in Article 10. Now this paints a beautiful picture. So the Florida Lottery is able to show us a diagram like the one you see before you, where it shows distributions to education that amount to enormous amount of money. If you follow the lottery ads on television, you'll find that these claims continue to be made. But the truth of the matter is that the Florida Lottery has given almost no benefit to education, because all the money that's come in from the lottery has been used to replace general revenue, and the Florida legislature has not lived up to the commitment that was made at the time that the lottery provision was adopted. We now go to that intriguing section of the Constitution, marine net fishing. Now, I left this in our discussion of Article 10 not because it's particularly important to you, but because it's a good example of legislative draftsmanship, and I want you to look through carefully this language. And perhaps in class, when we reach our class discussion, someone will volunteer to tell us what this provision means. Look at subsection 2. What does 500 square feet of mesh area mean? Can that be explained to us? Well, the draftsman tells us what mesh area means. It means the total area of netting within the meshes open to comprise a minimum square footage. The square footage shall be calculated using standard mathematical formulas for geometric shapes. Are you prepared to tell me or draw on the blackboard what this means? Is this understandable? Did the people of Florida have any understanding what they were adopting? Do the courts today have any understanding about what this means? Well, a little bit simpler to understand is the Everglades Trust Fund, which was adopted by initiative in 1996. And this has become very important for the protection of the Everglades. And again, it was adopted through a massive effort by Florida environmentalists to try to protect the Everglades. Section 18 deals with disposition of conservation lands. It allows those lands to be disposed of only when there's a determination that there's no longer a need for them, and upon a 2/3 vote of the governing board that controls the lands themselves. Section 19, HighSpeed Rail, was in our Constitution, and it was repealed by a 2004 amendment. We no longer have high-speed ground transportation system in our Constitution. Section 20 on tobacco smoke, again, a good example of the use of the initiative provisions. There was an attempt to limit tobacco smoking in Florida. The tobacco lobby was pretty quite strong. That legislation failed to pass, and through an initiative amendment, we now get Article 10, Section 20, barring tobacco smoke and as a health hazard. Another provision that I want to point out, just because it'll be fascinating to you as constitutional lawyers to know that we in Florida ban bad treatment to pregnant pigs. And this again came to our Constitution through an initiative provision adopted and now burdens our Constitution. Provisions relating to pregnancy, a requirement in Article 1, Section 20, Article 10, Section 22 that limits the ability to deny parental guidance to a minor. This measure has led to some litigation, and we'll discuss that in our class discussions. Slot machines in Article 10, Section 23. We've discussed this briefly before when we talked about amendments and we talked about draftsmanship, and our interest here was not so much in Article 10 as in slot machines as in the way this provision was drafted. Now look at it. This provision says in subsection B that the next legislative session occurring after the voter approval of the constitutional amendment, the legislature shall adopt legislation. Well, the next following legislative session did not adopt legislation. So what's your remedy? Can you now mandamus the legislature? The legislature is faced with a provision of the Constitution which says they shall do something. Now, what if they don't do it? What's your remedy? If you take it to court, will the court then adopt legislation? Now, remember, this is fairly complicated potential legislation because it now involves such things as whether you tax slot machines, and if so, how. Note again the way that the drafter has used a bait and switch. We now say that any revenue from slot machines in Broward or Dade County may now be, that revenue will now go to supplement public education funding statewide, to supplement public education statewide. There's been no supplementation. There's been a replacement of education funding. And so the legislature uses this money much like it uses the general lottery money. And there may be a really interesting lawsuit lurking in this language. Minimum wage, again, provision placed on the ballot to try to get out voters. In this case, attempt by Democrats to try to get out voters from their base, and a constitutional provision requiring a minimum wage sufficient to provide a decent, healthy life, and it now in subsection C sets out a minimum wage and provides that minimum wage shall be increased as inflation occurs. Section 25. Do you remember we talked earlier about provisions in the Florida Constitution that came about during the dueling constitutional amendments with doctors on one side and lawyers on another? It was all built around malpractice. Remember that physicians managed to put into Article 1 of the Constitution a provision that said that there was a limit on attorneys' fees collected in medical malpractice actions, and that turns out not to be effective because attorneys who are handling medical malpractice cases simply have their clients sign waivers of the right to certain fees and enter into contracts allowing for contingent fees within the limits proposed that operate under the Florida bar rules. And so the doctor's language came into the Constitution but was ineffective. Here, lawyers got one of their provisions in the Constitution, and it now says that patients are allowed to know, have the right to know, of any adverse medical incidents, that is previous medical malpractice by physicians. A provision in the Constitution providing for the educational programs for tobacco education. The money to fund this comes from the proceeds of the tobacco litigation that was brought by Florida lawyers against the tobacco companies. And those are the general provisions. As you can see, we cover everything from adverse medical conditions to pregnant pigs. It is a hodgepodge, but it does contain some very important provisions, and I hope you will study them carefully. Thank you so much.